When the virus started in Wuhan in China, it felt so far away. But today, Ghana is faced with COVID-19, and that's not all. There is a committee that was set up by Parliament to investigate our procurement of vaccines, or the failed attempt at that. On Face to Face today, we interrogate the work of the Ministry of Health in procuring those vaccines and the project that was undertaken by the Committee of Parliament, and whether or not that committee satisfied Ghanaians. My name is Umaru Sandamadu. You're welcome to Face to Face. My guest on Face to Face is a Futu Member of Parliament. He's Deputy Majority Leader in the House. And when the House decided to set up a 9-member committee to probe this particular issue of COVID-19 vaccines, the SPUTNIK V vaccines, he became the chairman. And so you can call it the Afenyo-Markin Committee. Honorable Alexander Afenyo-Markin, welcome to Face to Face.
Thank you. It's good to have you.
How are you doing?
Well, I'm fine. There's a never-ending demand on the job, and we are getting on with it. It's not an easy task.
But you're on recess now, maybe to give you some rest.
Well, you have some commitment to your constituents. You have to visit ECOWAS Parliament, the localized meeting in Abidjan, and the extraordinary session in Winneba, September. You're hosting the entire MPs of the sub-region.
Oh, after what you did recently?
Yes, there's going to be an extraordinary session in Ghana, and by the grace of God, government has allowed that to be in Winneba. So it's a preparation towards that big event. They will be here for 12 days, and we need to put in everything necessary to make their stay a happy stay and fruitful. There's no rest.
I must confess, I don't know Winneba that well. Do you have a huge event center, a place you can host all MPs from the sub-region?
There's no problem at all.
You do have big centers like that?
There's no problem at all.
Maybe I should come to Winneba more often.
There are facilities to accommodate them. There are facilities to make their stay pleasurable and profitable.
And this will be about how many members of Parliament?
115 members of Parliament.
From West Africa?
From West Africa. You have about 40 ECOWAS Parliament Secretariat staff. You are expecting some consultants or resource persons who would also come make presentations to committees. So all in all, we're expecting no less than 200 guests.
For 12 days?
Yes, and we have what it takes to host them. We have hosted 100 for 5 days, and they were happy. And we are preparing for the bigger events.
I wish you luck. We'll be there to see what you are up to as the ECOWAS Parliament. Now let's talk about our own Parliament here. You are chairman of the committee that was set up to probe this SPUTNIK V botched or failed attempt to procure vaccines for the population. What were the terms of reference for purpose of education? What were you supposed to do as a committee?
Well, among other things, we were supposed to determine whether or not the said procurement was in accord with Article 181 of the Constitution. We're also supposed to determine the pricing, whether or not there was a necessary justification, and whether or not a middleman was engaged in the process of the said procurement, whether or not in the process of the procurement PPA approval was sought. So basically, those
are the broad areas.
The specific areas of our engagement.
Okay, because there are more references. So I noticed
all matters relative to the entire transaction.
I see. So the primary thing you're supposed to do is to check whether there was a breach of a constitutional provision, correct?
That was not it. I didn't say that. Whether or not the procurement was in accord with Article 1815. It doesn't mean whether or not there was a breach.
Okay, whether or not there was an adherence to that provision, that's what you're supposed to check. That's what you're supposed to do. Okay, so let's take it one by one. On that particular term of reference, what did you find?
Well, We started our job in earnest after writing to the Minister of Health, and I must commend him. The swiftness with which he responded to us. We gave him 24 hours. Within 24 hours, he gave us every document we needed. So there was no standoff, as in delay and all that. The time we gave, he made himself available. We knew our commitment to the people of Ghana, so we agreed to hold the meeting or have the hearing in public, allow cameras in and all that. Yes, the minister brought us all documents regarding letters, including letters to the Attorney General. Suffice to state that the letter to the Attorney General was sent after he had signed the contract. And the Attorney General responded that the Al Maktoum transaction, because the party involved was registered outside of the jurisdiction of Ghana, it qualifies as an international transaction. Therefore, he should come to Parliament for ratification. And bear in mind that we've had a court decision on the issue of 1815. 1815, if you don't come to Parliament for prior approval, the law allows you, per the court, for you to come for ratification.
That's after.
Yes, ratification is allowed in our laws.
Okay.
And for the purpose of this thing, we better also educate the public and explain things. There are two ways in dealing with matters for good governance. If you are an executive in any institution, you first seek approval from your board when the law requires that. When you don't, the same law allows you to go back for ratification. That is getting them to appreciate why perhaps you had to do it urgently and then seek their concurrence. It is done everywhere in any advanced democracy. It happens. In all corporate institutions, chief executives have mandates to, in exigencies, in situations where the compelling demands are such that he needs to take a decision, he does it. Here, the caveat is that once you are done, come to the appropriate body for ratification. That is why even in the PPA law, there's a provision for ratification. So it means that the law envisages that there would be situations where a decision would have to be taken, and soon thereafter, you come back for the appropriate thing to be done. So this is what the minister did. He went to Attorney General knowing that he needed to save lives. He needed to act quickly and swiftly to get vaccines for the people of Ghana, but also mindful of the demands of law. He wrote to AG to seek advice. Meanwhile, when AG wrote, he indicated during his oral testimony that he was going to comply with the AG's advice, which advice was for him to come to Parliament for ratification in respect of Al Maktoum transaction. So, in effect, our findings were that, save that the minister had said he was going to come to Parliament, to the extent that the contract was entered into without prior parliamentary approval, and AG had said so. On the strength of AG's opinion of the law, we hold same to be true, that there was no compliance.
Okay. This ratification was supposed to have happened with Parliament after he has done it, and you said the law allows it.
Yes, I say so.
Did he ever take any step until the day you started probing this thing?
Well, he had indicated. He
wrote to Parliament that he's coming with an agreement like that? How does it work?
We have to be fair. He had indicated that upon receipt of the AG's advice, preparations were underway. And as a parliamentarian, I know how the executive starts with a documentation in coming to Parliament. And it was around the same time.
But you know, all these things happened in March. The AG's letter, March, April. That was a period all these things were happening. The AG's letter,
the
agreement was
in March.
He wrote
to AG in April.
Yes, the agreement was in March.
And he said that he was putting...
So I'm just looking at it this way. April, May, June, July, before your committee sat, 3 months. Did he
Let's take
ever,
him by his word.
Yeah, but did the ministry bring anything to your house?
I'm not a member of the health committee, but I'm saying that I take his response to us in good faith. That upon receipt of AG's advice, the plan was then to mobilize and come to Parliament.
But a good intent to be written will be submitted, would have been submitted by now, don't you think?
Well, you may have your opinion, but I'm saying that from his testimony, which I had no cause to doubt, I am relating to the answer he gave to say that he had indicated, because we put that question to him, that there was no way he was going to run away from the requirement of ratification. So that's the point I'm making.
Okay, so for you, he said to you that he was going to come to, and there's a possibility he was going to, and you have no reason to doubt. You have no reason to doubt. But your report suggests that notwithstanding, the intent notwithstanding, it is a breach of the constitutional provision.
We have said so, and I've said this in this interview, that save that he had given he had told us that he was going to comply with the AG's advice for ratification. We hold the view that the AG's opinion on the law is the correct position of the law. Therefore, there was non-compliance with 1815.
So let's speak normal person's English now. This minister, before he enters any agreement with someone like he did to get Sputnik V, should have come to Parliament. Fundamentally, he did not do that. If he would do it later, if he had planned to do it later, it's yet to be determined. He has said to you that he was planning to. It never happened. That is a breach of the law 1815, Article 1815 of the Constitution. When you breach the law, and for that matter, the supreme law of the land, there are consequences. Did your committee bother itself with that?
To the extent that he had given indication that he was coming for ratification. And you see, when the window is closed on him, is where we can say that, oh, the window is closed on you. He says, and he's a colleague member of Parliament, on oath, he says that, look, I wrote to AG. By the way, if he had no intention of getting to comply with law, ask yourself, why did he write to AG?
But he wrote to AG after
the
agreement
was
signed.
I'm saying that we have to also be fair by admitting that the law allows decisions to be made. All right? I've heard people say that there was lack of cabinet approval. I contest that. There is no such constitutional requirement that a ministerial decision must be subjected to cabinet approval before same can be effective.
I'll let us get to
no
there. Your committee has mentioned cabinet. I'll let us get there.
My committee didn't mention cabinet. My committee said there was a ministerial decision.
Yes.
And bear in mind that the man is head of entity.
Yes, your committee said there was no cabinet decision. There was
we
no
never said that. No, please don't misquote.
I'll look for that.
I am sure, I'm clear on the words we use.
Okay.
The committee emphatically stated that the decision was a ministerial decision.
Okay.
We never used the word cabinet. I don't know which report you are reading, and I challenge you on that.
No problem.
The committee said it was a ministerial decision, and I'm telling you on authority that there is no such provision in our constitution which says that there must be a cabinet decision to make a ministerial decision valid. I challenge anybody who says that there is such constitutional decision, and I challenge anybody who says that because there was no cabinet approval, the minister was wrong in taking a ministerial decision.
Okay. All right. I'm looking at your report. I'll be sharing with you specifically the part you talk about on cabinet. So on page 24, decision to procure the vaccines, you said the committee found, and this is your committee.
Go ahead.
The committee found that the ministry entered into 2 agreements without cabinet approval, but only based on a ministerial decision, having regard to the advice of the COVID-19 Emergency Operation Committee.
Yeah, that's the point.
Yeah, so
don't get it out of context.
No, I'm just saying to you
I am saying that don't
again on page 12.
Don't disengage it.
On page 12, there are 2 times the word cabinet.
No problem.
Report.
Proceed.
On page 12, paragraph 8211, you say the minister further told the committee that he did not seek cabinet approval before entering into the Al Maktoum procurement agreement, and that it was a ministerial decision that was taken. Good.
He doesn't need to.
So,
and I'm saying that, no, get the language used. Omar,
make your point.
With respect.
Make your point.
Let's get the language used, the phraseology right.
No problem.
I don't want anybody to say that there was lack of cabinet approval to suggest wrongdoing. No, you are talking law, and I'm saying for the people out there who are interested in this matter, where the minister is wrong, he's wrong.
Okay.
Bear in mind that this report is by consensus. And I'm saying that I don't want any Ghanaian or any civil society organization or any stakeholder in this our body politics to ever say or hold that view that a minister needs a cabinet approval to make a ministerial decision valid.
Okay.
There is no such legal requirement.
No problem.
And I say so on authority.
I believe.
So therefore, with respect, if the minister said, I did not seek cabinet approval, but that my decision was a ministerial decision, is so supported by the fact that the minister is head of entity, which you should know.
Yes.
For procurement purpose, he as the head of entity takes decision and gets his entity tender committee to preside over. Okay. And he provided us evidence of minutes of negotiations, minutes of meetings they held.
And made this decision.
Yes.
The point about the cabinet decision, I am not saying you have said it is a breach. I'm saying that.
But it is out there.
You cannot
that
control.
Cabinet did not approve.
No, you cannot
to
control.
Suggest that he was wrong. No. But we have a duty.
Yes.
Umaru, you and I have a duty.
If
you and I have a duty to explain issues to people, so that no student of political science
would make a mistake.
No
problem.
No lawyer or no stakeholder in our society would ever think that the minister did not go to cabinet to say that he has erred. That impression is being created, and I owe it a duty to my fellow citizens to explain
that
the correct position of the law.
It's not an obligation.
That no, it's not a matter of obligation.
It's not a legal obligation. Position. Yes, so it's not a legal obligation for a minister to go to cabinet and say, I want ABCD. But have you considered...
That is not the position of the law.
I'm saying, yes. So,
and nobody should suggest that.
Fantastic.
When a minister doesn't go to cabinet to validate his ministerial decision, the minister
has erred.
No
problem. Your committee was not tasked to investigate that, and it's not part of your term of reference. You have not mentioned it in your recommendation, but you have stated it in there that the minister has told you that he did not get cabinet approval.
It was mentioned because a member suggested to the minister whether or not cabinet approved, and he said it was a ministerial decision.
So you had to capture it in your report.
So we need to capture it as but the phraseology there must not be misconstrued.
Do you not think that, considering the magnitude of COVID-19, considering that the president during his State of the Nation, not State of the Nation, his fellow Ghanaians address, said to us that he was going to procure vaccines for 20 million of the population, any such decision to procure a deal as much as the money that was going to be committed to it, if Parliament was not informed, at least the President, his cabinet should be told? You do not think so?
Well, putting things straight and in proper perspective, the minister did not end at saying it was a ministerial decision. He didn't say that simplicity. He further indicated that there is a COVID emergency task force set up by the President. And bear in mind that that task force from day one has been responsible for the management of the situation we find ourselves. And the minister added that the matter came before the task force. And the task force supported his decision.
But the task force cannot substitute cabinet.
Well, there is no requirement for cabinet approval.
You do not, I mean, that's on the legal side. So you are restricting yourself to the legal side.
If you want to look at prudence, if you want to, from your angle of asking, don't I think that the quantum of the procurement required the cabinet approval? I am again saying to you.
Legally, no.
I'm again saying to you that for the purpose of prudence, because the angle you arguing is that of prudence. And I'm saying that if it's for prudence, then listen to the minister again. When he referred to the task force, bear in mind the task force does not report to the minister. The task force reports directly to the president.
Okay. Let's leave cabinet. Let's go back to 1815. The fundamental issue that you're supposed to find was whether or not the provision of the Constitution was respected or adhered to. You found that it was not. That is a crime under our statutes, isn't it?
Which law? Which crime?
The provision that says you should come to Parliament under the Balkan case, that you should come to Parliament for an international agreement. You have determined.
You said that it's a criminal offense?
I'm asking you. You are the lawyer.
I have not read any statute which says that failure to seek prior approval amount to an offense?
It is not?
There is no such law that I have read.
What does the Balkan ruling say? The judgment?
You see, it made a declaration that failure to seek approval it makes the contract or agreement null and void, of no legal effect. The issue of ratification also came to play, all right? That if you have really not sought prior approval and you subsequently have come to realization that this thing is void in law, what you can do is to come to the very body for ratification. There is no such criminal offense prescribed in the law.
So it is not...
That I know of.
So it is not unlawful for what the minister did contracting an international organization without parliamentary approval. That's what you're saying to us today.
I am saying that I have not read of any criminal offense that would implicate the minister in that circumstance. However, what I know is that when you don't seek prior approval and you are subsequently advised and you verily believe same to be true, you come for ratification. And ratification of decisions are allowed by law. You
are a lawmaker. This law we are depending on now may not necessarily have been made in Parliament. It was made in the Supreme Court, even though, it's still a law. And you're saying to us today that we have a law, and that law, if breached, has no consequence on the breacher? Is that what you're saying to us?
Umaru, point to a law to support your argument. It's not a matter of I am saying so. What is the law saying?
But is it not...
The law says that if you have to seek prior approval, we've had subsequent rulings that have said, yes, lack of prior approval is null and void. No legal effect.
Waterville and Isofoten, one of them, I think.
But I am saying that where you did not go for prior approval, the law allows you to come for ratification.
Yes, and I'm asking you for education and also for your comment that when we have a law that says do not do A, but if you do A, it's fine. Just fix it later. What if there's a consequence, financial
So there must
loss?
Be a law to back that.
So we don't have a law like that now.
But you can act within the law and still commit an offense of financial law to the state in implementation. All right? You can act within the law. The minister could come to Parliament for approval, and then in the implementation, in terms of how he goes about the implementation. So, for instance, let me give you an example. The payment that has been made.
Can you hold that for me, please? I'll come back. This is Face to Face on City TV. My guest is the chairman of the Afenyo-Markin's committee to investigate Sputnik V vaccines. And the curious case is that there is a breach of the Constitution, but that breach, we can't find a punishment for same, except that you can come and correct yourself or ratify yourself in Parliament, which ratification did not happen with the Minister for Health in relation to this issue.
At the time.
When we come back, as of today, there's no such plan in Parliament. It's not that we are aware of publicly. When we come back, I'll ask a member of Parliament, how useful is that law then? And what's the purpose of his committee if they could just tell us that someone broke the law and he can be punished? Don't go away.
This is Fact Finder from the BBC.
We live in a world where news travels fast. And sometimes, it's hard to differentiate fact from fiction. Fact Finder brings fact-checking from the newsroom up close so you can separate truth from chaff. Be empowered to tell what's fake from what's real. Watch Fact Finder by the BBC on City TV every Wednesday at 6 p.m. City TV. It's your world.
You're welcome back to Face on City TV. My guest is Afenyo-Markin, Deputy Majority Leader, Chairman of the Ad Hoc Committee of Parliament that was to investigate the Sputnik V vaccine procurement. Now, you were saying to me before we went on that break, and you are the lawyer, so I defer to you on these matters, that there really isn't a black and white law that says if someone fails to come to Parliament for ratification, for prior approval,
it's amount to a criminal offense.
Yeah, it amounts to a criminal offense, and that they should be taken through A, B, C, D.
I see that
I see that you have mentioned it in your report. It's in fact your first finding, because that's your first term of reference. But you continue to say that despite the fact that it was a public health emergency under which the minister was, that was what he took cover under, you still believe that he should have come to Parliament, which means that
even in our recommendation, even in our recommendation,
yes,
we stated that in future, the ministry should engage the health committee the more. In future, the ministry should not give that excuse, that emergency.
But we've always known this. You didn't have to put in a recommendation.
We have to. Why? That is why we were supposed to do this. If we knew of the consequence, then there wouldn't have been a need for a committee to investigate. All right? I'm saying that we, by consensus, dealt with the issues in an objective manner, void of partisanship. And that is why I am surprised that people are veering off the facts. I chair the committee. As a member of parliament, a lawyer, I would not do a cover-up on anything. The same way, I wouldn't also allow unfair judgment or allow myself into a misguided situation. I told my colleagues that it is only the persona dramatis that will change, but the Ministry of Health will remain a Ministry of Health. Put Agyeman Manu aside. Anybody else can occupy that position. Let us come out with a recommendation that will stand a test of time, that will send a strong message out there to all public office holders that once there is Parliament and you can take something through certificate of emergency, even in a day, utilize that, than to look for option B. I will do it and come for ratification.
Even though you are allowed, even though you are allowed to do that option B.
Even though you are allowed to do that, that should tell you how we cared about the people of Ghana, how we cared about the situation at hand. Now, yes, Mr. Minister, we agree with you. Pandemic, people were dying. We agree. It is true. You have to take action. If you had been laid back, the same public will criticize you. But we still told the minister that yes, you could still have complied with the law and would have given you our cooperation. So don't exercise option B. Utilize option A, because you would achieve the same result. If you had come here, that we should sit even up to midnight to look at your intention to procure. And you are told us that, look, yes, the GOG sources have failed me. And he was right. The evidence is there. All the government-to-government sources had failed. And the government had no plans of utilizing private sector sources. Government was comfortable with the ECOWAS arrangement and other arrangements that were coming. Suddenly, the Indian situation escalated. So India itself was not releasing vaccines. All other bilateral sources, according to the minister and according to the facts, had said, look, we couldn't supply you till August. We said, yeah, minister, we agree with you on that. You needed to act in the public interest. You needed to act to save lives. But Parliament was not on recess. Even if we were on recess, we could be recalled. So going forward, yes, you may be coming for ratification. That of PPA, you've written to PPA for ratification, which is allowed by law. The PPA Act allowed for ratification.
That's actually that's what I was going to go to now.
But you could have still come to Parliament
okay,
under certificate of urgency. You could have still written to PPA under certificate of urgency, and you would have gotten what you wanted.
So your findings again, you found that the minister or the ministry did not respect the constitution provision that talks about going to Parliament.
Using the word
respect,
perhaps it's too harsh a word.
Which word would you?
You see,
he did not come to Parliament. That's disrespect to Parliament under the law. That's one.
You can't say so. Once he has said that he had intention of coming.
He has never done it. So for now,
it doesn't mean that disrespected.
Yeah, but he has not.
Especially when he himself is a member of Parliament.
No problem. So my point is that he hasn't done it, and so on the face of it, it hasn't been done. So that's
that
one.
I agree with you.
Two, Cabinet, you have said that he's not obligated under the law to go to Cabinet. But you have also, the general view is that he should have gone to Parliament, he did not go. 3, Public Procurement Authority. That again,
he has gone for ratification.
That again, you found that he didn't go by the time he went to sign this agreement. Again, that's also not any criminal.
The law allows for ratification. You see.
But as of now, PPA has not ratified.
But they are working. They have not finished.
How many months after?
No, but I cannot answer for PPA, Umaru. I cannot answer
but
for
you can
PPA.
answer for the conduct of the public institution that was engaged in that act.
Umaru.
Yes.
PPA has written to them. When they wrote, PPA responded.
Yes.
And PPA says that we are doing our investigation. The word investigation is in context. That when you come for ratification, we have to now examine the entire process to see the justification. Then on the strength of that, we take a decision.
But PPA has emergency rules like you have in Parliament where you can do the...
That is why I'm saying that...
PPA could have also done what they call sole sourcing and all of those things.
I am saying that.
Yes.
He could have written to PPA under the same certificate of emergency.
Yes.
And
he hasn't done it.
PPA fortunately, the president gave the board an extension to still sit. So that option could have been exercised. But here we were, he took the decision and wrote to PPA for ratification. Your question is, has he breached the law? My answer is, under the PPA Act, you are allowed to seek ratification. Now, we can only talk about a breach when after PPA has conducted its investigations, it gives us a report
and says that
no. We are unable to ratify your decision. Then we say there's a breach. I want us, much as we are emotional, the atmosphere is charged. We equally owe a duty of to the viewing public, the listening public, to educate on the law. Because beyond the political question and beyond the political answer is the reality of the law, which people must appreciate. And that is what I think should be the basis for this engagement.
Let's look at it from a cynical point of view. If, for instance, this agreement by the minister was for us to go to war or for us to invade a country, he took this decision in March, signed that agreement. As we speak, your parliament has not approved it. Cabinet has not approved it. You have said it's not obligated. PPA hasn't given an action. The deal has been signed, and that makes it enforceable. Our signature is on it, as our minister has signed that. We would have gone to war and died and finished everything, destroyed, and we'll still be here discussing issues of due process that have not been followed, and you were saying that let's stick to the law. Should we always just say, well, that's what the law says, but also not consider the other repercussions of what he has done? Should your committee not have made a recommendation that due to A, B, C, D, we recommend A? Because there are people who think you should have recommended punishment. You did not.
Omar.
Yes.
I'm not good in Latin, so let me just put it in the English version. You don't put something on nothing. We recommend punishment when that punishment we are recommending will not have any basis in law. How do we recommend? 2, the hypothetical question you pose cannot be related to the matter in issue.
Why?
With all due respect. You see, for your convenience, you keep saying, in spite of the minister's failure to seek cabinet approval, upon all my explanation to you on the issue of cabinet approval not having any basis in law,
I kept referencing that.
You find it convenient.
No, I referenced
you can't. No. You are referencing it for your own purpose.
No,
and that is unfair.
For purpose of letting the people know.
But you are not letting the people know that there is no such requirement as cabinet approval. You are not saying that.
Since you said it to me, I have put it on every sentence I have said.
Yeah,
but my question is that
you just suppose it.
Many hold the view
yes.
that all these things that you have said, so going to PPA for ratification, coming to Parliament, these are post facto rationalization that
which in accord with law. Yes. The law allows for this supposed post-facto rationalization
these are just being cooked up now to satisfy or tick a certain box.
Please, with respect.
Yes.
Prior to they mounting the action on the floor of the House, PPA engagement had long commenced. So let's be fair.
Okay.
Let's be fair. Prior to they mounting the action in Parliament, letter to Attorney General for advice had long gone and responded yes.
After the signing.
Yes.
Are you supposed to sign the agreement before you ask the chief government advisor on legal issues whether you should sign it or not? What do you do?
Let me get you right. I don't understand.
So the question is, you're going to sign an agreement as a minister, and you have not been a minister before, but you have held a public office, or occupied a public office, and you still are occupying a public office. Do you tell the government's principal legal advisor after you've signed or before you've signed an agreement?
Omar, perhaps you want me to repeat myself, and I will repeat myself. When the law allows for ratification, you can rely on that ventilation. But in our findings, we said that it would have been prudent for him to have exercised the option A. That is, seek AG's advice before sign the agreement, come to Parliament before signing the agreement, go to PPA before signing the agreement. These were our findings, and it's there. We are not defending, you see, we don't want an impression to be created out there that perhaps the MPP side is defending the indefensible. What the MPP side is saying is that let's put the fact out there in its fair manner so that we don't pollute the minds of people. The committee was a bipartisan committee. We didn't write a majority report. It was a consensus, unanimous, jointly signed by the chairman and the vice chairman. And we put it out there. I'm not changing my position on what we found, but I'm ready to defend the facts and ready to deal with all mischief.
Okay. Please remove your legal cap. Let me ask you this question as though I were...
I am unable to remove it because the legal cap allows me to educate.
Okay. Talk to me as though I was a fisherman in your village.
Yes, and I know in the law.
Yes.
I will talk to you.
No
yes?
problem. Your job as member of parliament and members of parliament, and for that
and
matter,
a lawyer
and the legislature, is that
the fisherman will be happy to know the law.
Yes, no problem. As legislature, your job, as I believe it, for which reason I voted for you, is that you are supposed to be a check on the executive.
Oversight, yes.
Oversight, so balance, checks and balances. Would you, in this current circumstance, put hand on chest or hand on heart and say Parliament has truly exercised that oversight responsibility?
Super. Perfect. We've done so. To the extent that on the facts we were bold to tell our colleague that you should have complied with the law. To the extent that we were bold in making recommendation for future guidance. How else could we have been seen to be bold, courageous, to point out a wrongdoing? How else would we have put it?
Occupy Ghana has issued a statement and says that you have disappointed Ghanaians.
Well,
I can read portions for you if you want.
Don't worry.
Just to put the issue in
Don't
perspective.
worry. They are entitled to their views, and it's a far right. That is why we are in this discourse together. If they are disappointed, and they can mount the basis for such disappointment, I'll be happy to listen to them. But as far as I am concerned, as the head of that committee, no single fact was hidden. Look here. When the minister responded to us by saying that to the best of his knowledge, at the time he was coming to us, no payment, as in the direct transfer, cash payment had been made. We went further to now write the Ministry of Finance to check with Bank of Ghana and Controller.
And it became apparent.
Wait. Bear in mind that the minister brought us a swift advice of LC having been established, which in itself is a form of payment, save that it's conditional. Because when you have a site LC, which is a payment instrument, it must trigger through supply. But there was another provision for a part payment. And he said at the time, because the LC itself delayed in getting through, and that was a source of worry because there was a back and forth. So we said, okay, let's find out. Again, we gave the minister the mandate to check. And he sent an email to the suppliers to confirm whether or not, apart from the LC, they had received subsequently any direct payment, which is the commitment fee to enable them supply. And the supplier confirmed that yes, we have received, and that because we have terminated the contract, make a formal demand on us, and we'll refund the difference of the unsupplied doses. The ministry wrote a formal request, which letter they served as a copy, as a committee. And let me also clarify here. You know, the mid-year review, the finance ministry put in a figure, and that is what made us more curious. You see, I have dealt with financial instruments, so I understand certain terminologies. But in order not to allow for confusion, I said, look, releases are not payments. When the Ministry of Finance says we have released, it doesn't mean that payment has been effected. They've made releases to controller. Controller will now have to effect it at Bank of Ghana. BOG is the body that has the mandate to do the bank-to-bank payments. So I said, look, let's go a step further. We will get the answer. Look, we gave Ministry of Finance 24 hours to respond to us. Within 24 hours, the response came. We gave the Minister of Health that go further and check with BOG through controller whether this thing has also, apart from the LC that has been established, and check with the Maktoum themselves. They came back with all the facts. Okay. And on the basis of that, we said, take steps to recover
the money back.
In spite of the fact that they had already taken the steps, in spite of the fact that Maktoum had written that we cannot be unjustifiably enriched. You know, there's a law on justified enrichment. We have a contract. We have repudiated, or we have resolved, or we have terminated. Payment has come to us. We are ready in good faith to refund your money. Okay. That is why we are unable to also talk about financial loss.
So you are referring here to the 16 million cedis.
Yes, all these
things. Is that not supposed to make payment for some 50% of?
That's what I'm referring to.
So you're saying
in addition to the LC.
So you're saying that even though the vaccines have been delivered, 20,000 or so.
Half for the 20,000 we have to pay for. So yes, if you look at the email from Maktoum, they conceded that they haven't initiated the termination. Bear in mind that it's not government that terminated the contract. Okay. Maktoum wrote to government that we are unable to supply. Deliver. So we want to back out. Okay. That notwithstanding, we have already brought 22,000. No problem.
So we'll pay for that.
We have an unsupplied doses. Okay. So make a formal acceptance of.
So let me just get this. So we will pay for that 20,000.
Yes.
The 16 million. Until we retrieve it, we can call it financial, but we are expecting that we'll get it, and we've been given indication that we'll get it back, according to Maktoum. So we should rely on that and trust that the money would come back to our coffers. So we would have lost
from
nothing.
The correspondence we have seen. Okay. Government has not lost money.
No problem. Let me speak to you about issue of perjury. When people appear before your committees and they swear that oath, anything they say that is found to have been untruthful, you call that perjury, right?
They're lying under oath.
Lying under oath. There's an issue about how much was paid for the vaccine. The minister had appeared before a committee of Mr. Speaker and said he was not going to sign an agreement that involved paying for vaccines beyond $10. And as of the time he was making this communication to your committee, one of your several committees, that should be the Committee of Health, he had already signed this agreement for $19.
Yes, he was referring to government agreement. You see, unfortunately, Mr. Agyeman Manu has become a victim of circumstance, but that's a price we pay in public service. You come to public service, you should expect these things. We survive by grace. People can misconstrue you, and don't forget, and that's why I made reference to my colleague Akando. When he had put in his CV that positions held, school prefect, and it was out there in the media, dining hall prefect. And it was out there in the media that the man says employment history, dining hall prefect. He didn't make a mistake. He put it correctly. But it was out there and they lambasted him, gave it to him. He suffered all kind of humiliation only for people like us to look at the CV in the Hansard and say, no, you are being unfair. This is one of the instances that the public has not received the full facts. People are twisting to embarrass him. He might have erred in his appreciation of certain situations. But the point is that when he was referring to that figure, at all material times, the question posed to him was in respect of GOG sources, bilateral sources. And bear in mind that for bilateral sources, there was no third-party distributor or agent or somebody off-taking it. Okay. For bilateral sources, it is the bilateral source that has identified the manufacturer, negotiated with the manufacturer, and getting it for you from source. So he says that on that score, he will not pay more than that for that bilateral.
Has your committee established that indeed and in fact, the Ministry of Health could not succeed with the Foreign Affairs Ministry of Russia or the Russian government before going to Al Maktoum? Have you established that?
You see, let's not interlock it with another thing. The facts are that, one, government of Ghana had no bilateral arrangement with Russia in respect of supply of these vaccines. The arrangements were on different bilateral lines. When those bilateral lines were failing, government looked out for a private source.
I like that part. And that's the question. I just wanted a yes or no.
Now, the issue of whether or not Russia at the time had closed the chapter on any government-to-government arrangement is another matter.
Okay.
That's the issue, wait. You asked me at the beginning of this interview of the mandates, terms of reference.
Yes.
The issue of Russia was not part of my terms of reference.
Okay.
And I will not answer questions in respect of that.
On whether or not...
No, I'm not, because the issue of Russia was not part of my terms of reference.
Okay.
And we are here dealing with the issue of...
Because it's significant that
I do not see so.
If you have not exhausted the Russian angle...
We are not talking about Russia.
You do not go to... If you don't exhaust the Russian bilateral deal, you do not go to a private company. That's the view of many.
The minister was clear. In any event, his letters to the Russian minister and ambassador postdated his agreement. He said to us on oath that when the issue of Russia came up, he still took steps to explore it. But he was not successful. You are seeing an upsurge of infection. You have seen death rate going up.
You need to act.
And you need to act. In so doing, the areas that you knew of failed you. You get into another area which is promising.
You go fishing.
Because he didn't go fishing. He said people approached him. And then in the process, these people demonstrated capacity by shipping in 15,000.
That's proof.
That proved that, look, we have it available. And the minister told us institutions that benefited from those doses. And then said that soon thereafter, the issue of Russia, that these vaccines are coming from Russia, and that he should see whether he could explore. And he didn't say he engaged them before. He said he engaged them after. Because now it became apparent that Russia has the capacity.
Okay.
So if he acted in good faith by still proceeding, all right, to tap into bilateral sources, how then do we still attack him on that score?
We'll come back. This is Face to Face on City TV. I'm speaking to a member of parliament, in fact, leader of the house. You can describe him as
I'm a deputy. Please don't put me in trouble.
Second deputy.
Deputy
leader
yes.
of.
I have my boss, please.
Deputy leader of the House of Parliament. Now, Occupy Ghana has taken an attack or is attacking the House. I'll ask him to respond because it says that Parliament has left, the inaction of Parliament has left a huge gap in our governance structure. I'll speak to him on that. Plus, the request by Occupy Ghana for the minister to resign. What does he think? Don't go away.
City TV is live on DSTV. Go to channel 363. On GoTV, access City TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access City TV on your television. City TV can be accessed on a free-to-air digital box like the GoTV and Star Times box. City TV, it's your world.
You're welcome back to Face on City TV. We're still discussing your committee and the work you did. And I've noticed that you want to restrict yourself when it comes to the terms of reference when I mention Russia. There's something Occupy Ghana has said. In one of the paragraphs, it cannot be seriously contended that Parliament has not found that there are any modifications required. The facts show that Parliament's inaction has left a huge gap in our governance structure, allowing ministers to do as they please, and sadly ceded this important lawmaking function to the Supreme Court. This will go back to my fisherman question to you as a member of Parliament.
Right, so I know where my Professor Isankuma is coming from. We've had this debate in court. I agree with the position of Mr. Isankuma, which position has found its way into the bigger spectrum, Occupy Ghana. He holds a view, and I agree with him, that from the very day that Supreme Court took a decision in Balkan and subsequently Waterville, Isofoton, and all of those cases, that was a time for Parliament to have acted by coming up with the legislation. And because the Supreme Court said, we are not the ones to enact laws for you. In fact, the Supreme Court itself struggled in its definition of what is international commercial transaction, what is an international business. If you read the ruling, is it Dateba? You know, he was going round it, finding a proper interpretation or a proper definition. So, yes, I concede that to the extent that for over 10 years after the ruling, we have not brought up a legislation to regulate 1815. And I realize that you were struggling, that, okay, you breach 1815.
But it's nothing.
It's a political question. There must be a legal consequence. So that one, I think that the AG may have to take an interest to provide a game changer by coming out with a legislation. And I think if it comes, government comes with a legislation on 1815.
Okay.
It would help.
Let's get to the question of morality now. The people who are asking for the minister to resign or be fired, what will be your comment on that?
No comment. I've done my work. My work is founded on law, and I've discharged my duty. I concede that 1815 appears vague in terms of enforcement powers.
But also been breached as well.
Well, to the extent that the window for ratification has not been shut, I'm unable to go all out on that.
So you don't have a view on whether he should be,
I am saying that let us look more at something of substance to guide future governance, and which matter Occupy Ghana has raised, and which matter already know, so that we push the construct.
But you not discuss the issue of resignation or firing.
We should push the construct to the AG, that Mr. Attorney General, in fact, this issue of, lacuna
should be dealt with.
Ghanaians want to know how the law will react.
Honorable Deputy
How
Leader.
the law will react to situations where there is
Godfrey
failure
Dame
to
is watching the show. I'm sure he may take
there's
notice.
a breach or failure to seek ratification. There must be consequence. There must be a criminal consequence. So can you bring
and this is a punishment.
Yes, bring a legislation.
And then you work
because
on it.
The Supreme Court was not willing to do.
Should your colleague for Doma Central be fired from the executive based on all these things that you have seen and heard?
You've asked me and I've answered you.
That
you want to repeat it. I rely on my earlier response to you without more.
Finally, this work that you have done, even though we are discussing it, it's not been adopted by Parliament. So it's not really decided by the generality of the House. When should we see this adoption? And that's just in less than a minute.
I can't tell.
You have gone on recess.
I'm done with my work.
So it's not up to you.
It's at the discretion and pleasure of Mr. Speaker.
Mr. Speaker's second deputy deferred this.
The Speaker deferred,
Yeah.
and it is not my decision.
What do you make of that?
I
deferment?
defended my report, and I was ready to go on pound for pound
The minority,
with anyone who tried to create mischief, and that is what I did.
The minority in there during the debate said that you should add a clause in there before it is adopted. What do you say to that?
It is not founded on any rule. You see, there's a difference between a motion and a report. A report, you see, you move a motion to adopt a report. What Honorable Muntaka was doing, I can't see where it can be found in the rules. The rule is clear on amending a motion. What part of the motion was he amending? What he wanted to do was to seek leave to amend the report.
Mm-hmm. That's not allowed.
The rule does not allow.
Very well.
Because I move for motion. My motion paper is accompanied by either an affidavit or a report.
Okay.
I told the House that I am moving the House in terms of the report that the committee has to present. So you can't say that you are moving a motion to amend, you are moving a motion to amend a motion. Okay. Meanwhile, what you really want to do is an amendment of a report. The law does not allow that.
Thank you so much. Chief Advocate of the Ifutu traditional area, the man who is asking tourists to come to that area and even international visitors to come and work in his constituency. We are grateful that you invited us to your office and spoke to us on face-to-face. We are grateful.
Well, I am equally grateful. The pleasure is mine to be on your very respected platform. I mean, being on City allows you to learn. And I've never regretted any opportunity you offered me. I mean, you guys are doing an excellent work.
We appreciate it.
Very professional. Of course, you may err along the way, but that is what it is, human institution. So thank you, Maru.
Thank you.
It's a pleasure.
Thank you.
To be on your program.
That's Honorable Alexander Afenyo-Markin, a Ifutu Member of Parliament, Deputy Majority Leader and Chairman of the Afenyo-Markin Committee on COVID-19 Vaccines, the SPUTNIK V procurement. We'll be back with more on City TV. It's a pleasure to be with you as always. City TV, it's your world.